Hello, and welcome to the podcast Justice Unbound, about women, religion, and the State of Israel. In this podcast, we take you behind the closed doors of Israeli rabbinic courts, where all hearings are held in camera, closed to the public, and where the state applies religious laws to decide the fate of women trapped in marital captivity, agunot, of children stigmatized because of their mother's sexual partners, mamzerim, of converts who do not keep the Sabbath, and where citizens are cross-examined about whether they are Jewish enough, and much, much more. Justice Unbound is written and produced by the Center for Women's Justice, CWJ. I'm your host, Susan Weiss.
And I'm your host, Rivka Lubitch. Today's story we've entitled Beat, Raped, and Cheated On, or as we call it in Hebrew, Takaf Anas Bagad. This time, it's not one of my cases, but one of Susan's, and it has taken on a sort of iconic status in the Center for Women's Justice. We will use Susan's case to examine the main question that we raised in prior podcasts, and it's a huge question. What is a cause of action for divorce under halakha? Or in other words, what facts must a woman prove in a rabbinic court in order to be entitled to divorce?
If any. What if a woman proves that her husband beat her, raped her, and cheated on her? Takaf, anas, v'bagad ba. Or, let's take the fact patterns we described in other episodes. What if a woman proves that her husband actually married another woman, infidelity? Or what if she proves that she is so disgusted with her husband that she cannot bear to sleep with him, lack of intimacy? Or what if a woman's husband was so vicious towards her that he was convicted of a crime and sent to prison? Cruelty, infidelity, cruelty, lack of intimacy, abandonment. All these allegations of fault have historically been grounds for divorce in Western democratic countries. Under the fault theory of divorce, a person is entitled to a declaration of divorce from the state if they can prove that some fault or blame for the breakdown of the marriage lies with their spouse. If fault is found, it is not necessary to get the agreement of the spouse who is at fault to the divorce.
So does Jewish law adopt a fault-based divorce regime? Must one prove fault to be entitled to divorce under Jewish law? And if so, are men held to the same standards of fault as women are? Is there a double standard? And what about no-fault divorce? Most modern courts understand that fault is hard to pin down on one spouse as opposed to the other, and often hard to prove. Under no-fault jurisdictions, it's often enough for a couple to prove or even just allege something much more vague like the irretrievable breakdown of the marriage or irreconcilable differences. Then the court will issue a divorce decree by mutual consent, though the court will often require a cooling-off period or a period of separation before it will issue the divorce decree. So does Jewish law adopt the idea of no-fault divorce? Can a couple simply agree to call it quits? And if it's a matter of consent, is there a cooling-off period? We will answer all these questions. But first, Susan, tell us about your case.
My client was your every woman. There was nothing about her that was out of the ordinary or unusual. She was not illiterate or a person with mental or emotional challenges. She had a college degree, a job, a husband who was an accomplished businessman, and she had what would have appeared to be a wholesome family, a bunch of middle school and teenage kids. She lived in a close-knit, modern but religious community. When she came to me for help, she was probably just about my age. She told me that her husband had hit her, had forced her to have sexual relations with him, and that he had slept with another woman.
So hence the mantra, he beat her, raped her, and cheated on her. Takaf anas bagad. In essence, it was the quintessential fault case.
Exactly. And for me, this was an exciting case.
Exciting? That's a strange adjective. Why was it exciting for you?
Well, I wanted to understand what I needed to prove in a rabbinic court that would entitle my client to some sort of relief. Was any fault of the husband grounds for divorce? And this husband, at least according to his wife, my client, was really bad, and certainly to blame for the breakdown of their marriage. I also had just finished giving a lecture in Ben Gurion University about working in the rabbinic courts. For that lecture, I interviewed leading Jerusalem divorce attorneys. I wanted to know how many times in their careers had they actually obtained some sort of operative decision from the rabbinic courts about whether or not a man should or must divorce his wife.
Okay, and?
And the answer was staggering. No attorney had ever received such an order. One of the most prominent attorneys, Moshe Drori, who later became a judge, told me that he was currently working on a case in which he thought the court might issue a decision of chiyuv, a statement that a husband was obligated to give his wife a religious divorce. But this was his first such case after tens of years, I believe, of working as a divorce attorney.
Wow. So what actually happened in your case, the Takaf Anas Bagad case?
Well, the district rabbinic court held that I proved my case. It declared that the husband had been violent and unfaithful. It also held that my client was so disgusted by her husband that she could not be expected to live with him.
Wow, and then?
And then the rabbinic court proclaimed that under the proven set of facts, Jewish law required the husband to divorce his wife. Chayav legaresh et ishto.
So you won. That's great, Susan.
Well, I thought so. I was so excited. I had achieved a decision that was largely precedential in the Israeli landscape at the time. But I also knew that in order to divorce your wife by giving her a get, a Jewish bill of divorce is not a declaration of divorce. The couple is still married until the husband actually places the get, the bill of divorce, physically into his wife's hands. The rabbinic court cannot give a get instead of the husband.
Okay, so after the decision, did the husband agree to the get?
Nope. Not only did the husband refuse to give a get, he appealed to the high rabbinic court. He wanted the high rabbinic court to overturn the ruling of the lower rabbinic court. He argued that I had not proved my case. But moreover, he argued that the district rabbinic court erred in its interpretation of the halakha. The husband claimed that the halakha does not require a man to divorce his wife if he is violent or committed adultery. Before it can issue such an order, the court must first warn the husband so he can try to correct his behavior.
Oh my. And the rabbinic high court agreed with the husband?
Yes. The high rabbinic court cited the opinion of the Ramah, a 16th century decisor from Poland who wrote a gloss on the Code of Jewish Law, the Shulchan Aruch, stating that a man must be warned that his behavior is unacceptable before a rabbinic court will order him to divorce his wife. And as for the claim that a man is revolting to his wife, the high rabbinic court held that such an argument could only result in a decision recommending that a man divorce his wife, not one ordering him to do so. Because if the unilateral, subjective claim of a woman that she was disgusted with her husband was reason to order her husband to divorce her, no woman would stay married.
Right. The Hebrew saying is, Im ken lo hinachta bat le'Avraham Avinu sheyoshevet tachat ba'ala. No woman would still be sitting under her husband that is married. Well, there went any achievement that you thought you had. So here's a client who was raped, attacked, and cheated on, and you thought you got a great decision, which would have obligated the husband to give a get, and instead the rabbinic high court overturned it. You didn't even get a recommendation that it's a good idea if he gives the get. And then what happened?
My client appealed with another attorney to the Israel Supreme Court.
Okay, Susan, let's make it clear for our listeners here that the Supreme Court in Israel is a secular court. It is the Supreme Court of the State of Israel. It's not part of the religious court system. Sometimes the Supreme Court will review a case decided by the rabbinic courts, but only if it can be argued that the rabbinic court exceeded its jurisdiction or did not obey the rules of natural justice. So why did your client turn to the Supreme Court? What did she expect to achieve by that?
She asked the Supreme Court, again among other things, to direct the rabbinic courts to interpret halakha in line with modern notions of freedom and liberty. In essence, more in accordance with the holding of the district rabbinic court, which had decided that a husband had to divorce his wife if she had good reasons to want to divorce him. But the Supreme Court did not agree. It held that by law it would not and could not sit as a court of appeals on decisions of the rabbinic courts. What's more, it held that it would not and could not interfere with the halachic determinations of the rabbinic courts.
So let's hear. What did you learn from your beat, raped, and cheated on case, Takaf Anas Bagad? And why do you call this case iconic?
Well, Rivka, I call it iconic because I learned 3 important things. The first thing that I learned, and the most important thing that I learned from my case, Rivka, is that a woman has absolutely no grounds for divorce under Jewish law. No fault of the husband is grounds for divorce. A woman can prove that her husband raped her, beat her, cheated on her, married someone else, did not have sex with her, or that she is disgusted by him. It does not matter. A woman cannot be sure that a rabbinic court will help her out in any way. At best, a rabbinic court might order the husband to give a get, like the district court did in my case, but this is not a divorce. The rabbinic court will not and cannot declare the marriage over or give the wife a get instead of her husband. If the husband refuses to give the get, she stays married, maybe even forever. In 1977, the Supreme Court explained the situation as follows. כידוע, גירושין על פי דיני ישראל אינם מבוצעים על ידי פסק דין של בית משפט או בית דין, אלא על ידי הצדדים עצמם, ותפקידו של בית הדין הוא רק לפקח על הגט. Freely translated, this means, as is common knowledge, divorce in accordance with Israeli law does not occur when a rabbinic court or a civil court declares the marriage over. It occurs when the parties themselves agree to divorce. And the role of the rabbinic court is to oversee the get, the religious ritual in which a husband delivers a bill of divorce to his wife. In other words, rabbinic judges in Israel are bureaucrats who make sure all the technicalities of the religious divorce ritual are meticulously met. They have nothing to say about whether a couple is married or not. It will only occur when the parties agree to give the get. In legalese, this means that a Jewish woman has no cause of action for divorce because nothing she proves in court will definitively result in a court declaration that her marriage is over.
Susan, I'm not sure I would say that there is no cause of action for a husband. It's true that if a wife does not agree to divorce, the rabbinic courts will not declare the marriage over. But the court will and can make operative decisions that effectively end the marriage if they think that the woman is at fault and the husband wants a divorce. The rabbinic court will issue decisions requiring a husband to deposit a get with the court and will then allow the man to marry a second wife. So I think the characterization of the Supreme Court of the role of rabbinic courts is not exact.
Yes, I would agree with you. I was witness to a case in which a rabbinic court allowed a husband to take a second wife when his wife suffered from postpartum depression and had stopped sleeping with him. So there's lots that a rabbinic court can do, even if they cannot declare the marriage over for a husband. I would go so far as to say that under Jewish law and under Israeli law, no fault of the husband is grounds for divorce, but almost any fault of the wife is grounds for a de facto divorce by order of the court. There's a striking imbalance of the law, inequality, and extreme double standard.
Wow, this is pretty awful. And let's go back to your case. What is the second lesson you learned from Takaf Anas Bagad case?
The second lesson I learned is that salvation will not come from the Israel Supreme Court. It will do everything it can to avoid confrontation with the rabbinic courts. It will not dare to interpret the halakha and will always defer to the discretion of the rabbinic courts, even when the halakha is harmful to women.
It certainly seems that way. And by the way, Susan, we know this, that the Israel Supreme Court, salvation won't come from them. We know it from a lot of other cases that we may bring in later episodes.
Yes.
But for sure, for Agunot, they're not helping us at all. And the third lesson, what is the third lesson that you learned?
Rivka, the third lesson that I learned is about the unpredictability of the rabbinic courts and the fluidity of the halakha. There is no way to predict how a rabbinic court will decide the halakha. Will it decide the halakha in accordance with the holdings of the Ramah from the 16th century in Poland? That husband must be warned that his bad behavior might require him to divorce his wife, like the high rabbinic court held? Or will it rule more like the lower court, which declared that according to the halakha, a man must divorce his wife if he were violent or unfaithful, or even just if his wife cannot stand him?
Susan, I'm aware of the fact that some of our colleagues, as well as some experts in Jewish law, claim that things have gotten better for women in the past few years in the religious courts. Though a rabbinic court is still unwilling, or more accurately, unable to declare marriage over if a man refuses to deliver a get, those colleagues and experts will say that rabbinic courts today will, at least in some cases, obligate a man to divorce his wife if the couple is living apart for more than 6 months, citing Rabbi Chaim Falaji, a Turkish decisive from the 19th century. And the rabbinic courts will also order a man to give his wife a get if they are under the impression that both parties are fed up with each other and want a divorce, citing Rabbeinu Yerucham, a 14th century decisive from France. In other words, those colleagues might claim that today rabbinic courts have adopted modern no-fault ideas. A woman no longer, they will say, has to claim that her husband beat her, raped her, or cheated on her. It's enough for her to prove that she is separated from her husband and that the marriage has broken down. But I don't really think that this has become the norm.
This is indeed an interesting claim. I am wondering how widespread this no-fault policy actually is. Is it applied by all rabbinic courts? Is it applied equally when women are asking for divorce? Or is it only when a man wants a divorce? What happens on appeal? We will be inviting some of our colleagues to address these questions in future podcasts. But still, even if the rabbinic courts have reformed themselves, if I may use that term, it does not change the bottom line for women. Under Jewish law, women have no cause of action for divorce, as that turn of phrase is used in the legal world. Nothing a woman says or proves will result in a divorce. Even if a woman proves she is separated from her husband for 6 months or more, and even if she proves that her husband hates her as much as she hates him, a woman will still remain married so long as her husband does not give her a get. Fault or no fault, a rabbinic court cannot issue a divorce decree in favor of a woman. And then let's remember that we still have the problem of unpredictability. What is the halakha? Rabbeinu Yerucham from 14th century France, the Ramah from 16th century Poland, or Rav Falaji from 19th century Turkey? And why, for heaven's sakes, are we quoting these rabbis at all in modern-day Israel?
Okay, so to recap, according to you, Susan, there is no cause of action for divorce for Jewish women who marry under Jewish law. There are qualified causes of action for Jewish men who can be given dispensation to take a second wife. Don't expect help from the Israel Supreme Court, and the halakha is unpredictable. Oh, and let's not forget to address the question of consensual divorce. Though no fault of a husband may be grounds for a woman to get a divorce, if the husband agrees to divorce, a Jewish couple can get divorced immediately and without any waiting period at all. All they have to do is ask the rabbinic court to oversee the get ceremony. They do not even need to show a divorce agreement.
Yes, the halakha allows for divorce if the husband is willing to give a get and the wife is happy to receive it. The halakha does not require separation of any amount of time before divorce. No waiting time at all.
So it is really a bit confusing when you try to understand the logic. Some people claim that it is good that it's not easy to get divorced under Jewish law, but on the other hand, we see that it can be very easy to get divorced. So what is the policy behind all of this?
All this reminds me of still another case of mine when the couple kept getting divorced and remarried every time they had a fight.
And I have a story about a really awful husband who sat in jail for abusing his wife, and that still wasn't enough to get the rabbinic court to do anything. But we'll talk about this in another episode, so stay with us. But remember the 3 lessons of today.
1. A woman has absolutely no grounds for divorce under Jewish law. No fault of the husband is grounds for divorce. 2. Salvation will not come from the Israel Supreme Court. The Supreme Court will do everything it can to avoid confrontation with the rabbinic courts. The Supreme Court does not dare to interpret the halakha and will always defer to the discretion of the rabbinic judges, even when the halakha is harmful to women. 3. There is no way to predict how a rabbinic court will decide the halakha. Rivka. Oh no, my God, indeed. I think we'll wrap things up for now. This has been a lot for our listeners to absorb. We hope you'll stay with us for more. We have so much to talk about. Thank you for listening to our podcast, Justice Unbound, Women, Religion, and the State of Israel, produced by the Center for Women's Justice. We would love to hear your comments and thoughts. Please reach out to us on social media or on our website page.
This podcast was produced thanks to the generous support of the Gimprich Family Foundation. Thank you, Rachel Stomel, for all your help. I am Rivka Lubitsch.
And I am Susan Weiss. Thank you for listening.